Green light turns on and twice again to turn it off. And when we go on break, we have to turn it off because even though the broadcast is paused, the audio is not. So at breaks, make sure we're on mute.
For those of you who are challenged, it does say push.
Twice though, it doesn't say push twice. You actually have to push it twice.
Push twice. All right, Roy's gonna manage.
Is it double click?
Roy's gonna manage.
Okay, Roy's in charge, so I'm comfortable over there then.
Yeah. We're in big trouble. He's in charge of the buttons.
He'll let us know when we're on.
Oh.
Do we have a 5-hour agenda today?
7.
We're live.
Okay. Good morning, everybody. So we'll officially call the California Board of Legal Specialization meeting. Sorry. Good morning, everybody. We will officially call the California Board of Legal Specialization meeting to order at 10:06 a.m. I'm Rob Hershenson, and Adrian will conduct roll.
Coulter?
Here.
Esmond?
Here.
Hershenson?
Here.
Lester?
Here.
Levin? Shepherd?
Here.
Torres?
Here.
Thank you.
Okay, thank you, Adrian. So we'll start off today's meeting with calling for any public comment. If there are any public members on the phone or present, there are none that have any comments they wish to make. Now's the time. Okay, hearing that there are none, we will move on to the next agenda item, which is staffing updates. And Amy will give us some staffing updates.
Good morning. We have a short staffing update. We currently have a vacancy for a program specialist in the legal specialization area in the Office of Admissions. And we are, staff internally are working to get that position filled. And we anticipate doing that in the next month or so. Next item that we'll be talking about are the Appendix I updates. So as you may recall, we have been going through some changes and implementing board decisions. We've decided to keep this agenda item until all implementation is complete for legal specialization. And just to, do you have the clicker? Anybody have the clicker? Oh, thank you. So, there we go. So, as you may recall, the board made decisions in 2018 related to legal specialization. Those decisions require a state bar rule update, and the plan for legal specialization is to bring the proposed rule updates to the board for a 45-day public comment period in March. When that happens, we will send a copy of the proposed rule changes to the CBLS. It'll open, and in March, that meeting is held around March 14th and 15th. Feedback will come back to the board in May of 2019 with a potential implementation date of July 2019. And just so that everyone's aware of what the rule revisions will include, this is a quick summary of what will be contained in that set of proposed rule changes. First is to change the size of the CBLS from 15 to 7 members, of which at least 5 will be attorneys and up to 2 non-attorneys. Rule 3.92 will be repealed so that we no longer have advisory commissions, and the term working groups or working group members will be replacing commissions in rules 3.95, 3.120, and rules 3.121. Also, rule 3.93 sets forth the term limits so that board members are appointed for 4-year terms. That's going to be repealed, and the committee terms will correspond to the ones that will be addressed in the board book, which I believe are 3-year terms. Rule 3.94 will be repealed to conform with Bagley-Keene. So this is pursuant to Business and Profession Code 6026.7. It requires that we modify rules 3.94 and 3.96. The word member will be replaced throughout all of the rules, and it affects specifically rules 3.110 and 3.114, so that member replaces licensees replaces members. And the following rules are going to be revised so that it'll note the state bar instead of the board or commission as carrying out various functions. This includes approval of legal specialization, specialist education, acceptance or rejection of computation of various tasks, the legal specialization examination, references, waivers, modifications, recertification, action on an application, informal conferences, suspension or revocation of certification, and the issue of a denial of an application. And because the state bar is the entity that will be issuing that denial, the rules will be revised again from with state bar rather than commission. And lastly, Rule 3.126 will note that the California State Bar is the group designated to certify in legal specialization in California.
I have a couple of questions, if I can. On the first one, on Rule 3.90, it says at least 5 attorney members and 2 public. So if it's limited to 7, isn't it exactly 5 attorney members and 2 public? Or does it mean that there could possibly be 1 public member and 6 attorney members?
That's a potential. At least 5 have to be, so if we go 6, then we'd have 1 public member.
So is there a provision that there has to be a public member, or is the public member being taken away as well?
It's not being taken away. At least 5 have to be.
At least 5, but no more than 6?
Yes.
Okay. And then the second question was on the modifying terms. Does that exist? Will the term limits be in place for those that are already on? So if it moves to 3 and somebody's at 3 years and it's been a 4-year, will they term out at that point?
Most likely, yes.
Okay. Any other questions or comments?
Yes, just a couple of clarifications. So revising advisory commissions to working groups is actually just a kind of takeoff for, what are the changes to the advisory commissions that we're not seeing in this that are changes to the CBLS?
That is my next slide. This is specifically just relates to the rules revision, so I will get into that as soon as we're done with the rules revision.
Okay.
Okay.
I have a question, and I don't see it here, but there is revisions to Rule 6.70, sub-entities subject to conflict of interest policy. I don't see that on the list, and I think it's something that we should probably discuss since we're a sub-entity that would be subject to that rule.
So a set of proposed rule changes was presented to the board at the January meeting, and I can circulate those along because they're currently in an active public comment period that closes in March. So I will send that first set because the conflict of interest policy is a global sub-entity change, and that was part of that package. The rules that are going in March are specific to CBLS, so the ones that are in current circulation, I will send to you.
But it's in current circulation, but it's subject to public review, and it seems to me that it should be something that should be discussed among us since it directly impacts each of us and our ability to be a member of the CBLS.
Okay. So do you want to bring that up as a discussion item now?
If we could, why don't you go through your list and then maybe we can,
Okay.
maybe you can
And then
pull
we
that,
can pull
maybe
it
you can
up.
pull that rule up and we can have a
Yes.
conversation.
And if we can, just acknowledge that, I don't know if we need to officially take a new role, but we have an additional member of the board has joined. Adrian?
It's thank you.
Thank you.
All right. So now, the Appendix I initiatives that impact the advisory commission. These are the next steps of activities. So again, given that the cessation of advisory commissions require rule change, we will proceed, as you will see later, when we request the chair and vice chair nominations. We're going to proceed with meetings. Our next meeting with the advisory commissions will take place on March 7th and 8th. Some of those meetings are in person, others will be a teleconference. The intent of that meeting is to give everyone an update as to the status of the advisory commissions, as well as to complete file reviews that will eventually come to the CBLS, and to complete exam development. That is pre-testing some questions and selecting questions for the upcoming exam. At that point, we'll also alert the groups that the commissions will sunset. And we want to also invite the same members to continue and stay on our roster for potentially to serve as exam graders, as part of the development team, or even perhaps to represent the representation on this committee itself too.
Any comments
Any
or
questions?
So I just want to get this clear. So it's the change to the CBLS rules was to just basically change the reference from advisory commissions to working groups. Who are going forward? Are these working groups going to be essentially like subparts, like made up of CBLS members? Are they going to be made up of people taken from the essentially what we have as the advisory commissions right now? What are they essentially going to become?
So advisory commissions, if you think about the various functions that are carried out, we talked about it in the context of exam development. We talked about it in the context of also review the applications. So the rules specify that, or the proposed rules, that the review process will be carried out by staff. But we know that we're going to have to confer with the pool on complex applications. We've talked about that here in the past. And so the idea is to keep a pool of members from the advisory commission that can serve as consultants for that and become a working group when that need arises. And a working group in the sense that we would formulate them when that need comes up. In terms of the examination development and grading process, we want to model that for how we carry out the state bar exam. And so they would be paid positions the same way we pay bar exam development teams. And so that is the creation of what we're calling the legal specialization, examination, development, and grading, the LEDGE team. So essentially, advisory commission members have the opportunity to either become exam graders or developers, as well as being able to sit as working group members when the need arises.
So there were times on the BLAC where applications for certification came up, or applications for recertification came up, where it was because of the special knowledge of the members of the commission that those applicants got scrutiny on their certification, which otherwise doesn't exist in the state bar. How is it proposed to replace that type of professional scrutiny that arose as a result of the members of the BLAC and their knowledge of applicants or the law?
That's what we're intending to keep with the development of this working group. So when we have applications that are either complicated, flagged for questions, we would have access to this working group that could help us. And regardless of whether they are from one specific advisory commission, we're trying to create a working group with representation from all of the advisory commissions.
Would there be working groups specific to areas of specialty?
Yes, we want all specialties represented and focused on the certifications and recertifications.
And how would those working groups be constituted?
What we want to do at this advisory commission meeting, and the first one is just talk about the interest itself, and probably we'll have a follow-up meeting where we will ask for nominations so that we can get the groups formulated.
Is there going to be a specific number of members in each working group per?
We have not gotten that
Okay.
specific. Again, what we're trying to do, because these are groups that will probably be formulated and dissolve. And so in terms of how many and the length of time, like the tenure, has not been addressed yet. Because we're doing it on an as-needed basis,
So in theory, it could be potentially just one person representing the whole area, or
potentially,
0.
yes.
Okay, and like you said, these will essentially be, at least how I'm understanding what you're saying, kind of ad hoc, sort of like, as needed, you go into the pool of this working group, you for this particular question, and I take it is 100% the discretion of the staff when they need to go to the working group, right?
Yes.
Okay, so there will be, staff will be handling, let's take the average, there's no such thing as just like the cookie cutter kind of like certification or recertification. But if a certification, if a specialization application meets all the requirements and all the checkboxes are, and I remember like doing the file review, all the checks like on the top of if it meets those, and is my understanding correct that application will not be reviewed by anybody on the working group?
Yes, but we will still have a dual review process. And so what I imagine is in the event that we do have two opposing, determinations on an application, perhaps those could also come to the working group. So all of that stands to be determined, but I think what we're trying to do is still access this group as an advisory group for those types of decisions.
So there were times where there were the references that were given for an applicant. And those references can be rather telling of an applicant and telling to members of the advisory commissions because they're in the profession and they are aware of the other professionals in that specialty. How will staff meet that type of discretion?
Sorry, I just wanted to add to the conversation. I think that would be a really good point to bring up with the advisory commissions when we meet with them in March. Administratively, staff already reviews the applications just to confirm completeness, certificates of attendance, task and experience, etc. So the thing that Amy was referencing is those that don't necessarily meet the requirements or have a supplemental letter, a normal course, staff would present that to the commissions for further discussion. Due to the volume of files that we get, those that are generally administratively complete, those usually get an easy sign off just based on advisory commission experience. I think when we meet with the commissions and meet with them in March, we can maybe work with them or the potential working group to establish guidelines and helpful things that certain nuances that the commission can relate to staff. So we can establish a standard for file review. Currently, for the most part, it is standard, but there are certain things that some commissions look for in terms of their task and experience, and they know to flag them. So it would be hopefully the responsibility of the commission before they sunset to impart that knowledge to staff so we can at least flag for those things for a working group to discuss if needed. There's a high volume of applications, and through AIMS, we hope that it'll be more automated and just finished administratively. But again, we would definitely talk to the advisory commissions in terms of what types of things would we need to flag for a working group to address in the future.
Okay, and to take off on that, I think that that raises the prospect for me of and to Donald's point that there may not potentially be in some of these working groups, there may be like one or maybe even zero specialists from.
You're assuming the file even makes it to a working group. It sounds like there's potential for no peer review at all.
Right. But I'm just like, and that I think that I anticipate that the advisory commissions are going to be, a bit skeptical. I'll use that word of some of these changes, but. Even assuming that the ones that are that everything checks out, that those could be reviewed, the the prospect of having a, not problematic, but an application for server research that raises problems and having 0 or maybe just 1 specialist from that specialty field on the working group pool, because again, these are like ad hoc things that like we just reach out and say, that strikes me as a potential like red flag, just because I know a lot of specialists, for instance, if I were in that position, I would feel a bit reluctant to essentially be judge, jury, and executioner on an application without fellow specialists, without say, I mean, I'm just picking a number, without at least, 3 specialists from each, like, so there's some consensus within, people of this working group, because I think that could be a potential kind of like a public protection thing that might be slipping through the cracks.
Yeah, because the peer review process, now, this is my 11th year of public service to the certification program. And the peer review process has always been a cornerstone of this program. And we've been able to be very proud to say that we protect the public interest because the approximately 5,000 certified specialists of the 330,000 licensees are subject to peer review. And we, of the CBLS and the specialist program, the 5 people that I've been working with all these years, it is the peer review that is where the public protection truly comes in. And there have been, and I know we've all gone through the process, where there have been people who have not been certified. There are people who have not been recertified. And that's what some of the most difficult problems that sitting on the advisory commissions that we've had. It would be a real shame if that peer review becomes digitized. Because it's the fact that the professionals on the commission know their specialists, they know the specialties, and there's that special peer review that they're able to do. And I will voice my concern that losing that is a critical loss to the certification program.
Well, let me just say this. So given that we really haven't made a determination about how many volunteers we're looking for and how often we meet, I want to maybe pitch this idea, if it would address some of those concerns, is if we propose to select, when we're looking for volunteers for these ad hoc working groups, a minimum of 3 from each of the specialty areas, and that we perhaps look at these applications on a quarterly basis so that we don't lose that insight if that were built into as part of the process. So for this isolated request for looking at the search and research, we met on a quarterly basis with this ad hoc working group that would include at least 3 people from each of the specialty areas. When we have those applications, would that help allay some of these concerns?
I mean, I will speak up on that. I mean, that's helpful in certain ways. However, it only addresses situations that are coming up from the dual review that is occurring, which has no peer review component. I mean, I think that we are losing tremendous support by having that peer review component that seems to be eliminated if we accept whenever it's flagged as a potential concern.
Right. And to echo Donald's concern, I remember there were numerous times reviewing files when I was on ALAC where people checked all the boxes, where everything was cleared, and theoretically it would have just gone through. If we were just doing it by the numbers and all the requirements, it would have gotten through, and something stood out. There was taking credit like for a case that wasn't there. I mean, I can't really remember some of the specifics, but like that did happen. It wasn't super often. Like a lot of the debate and deliberation by the commission was about people that were trying to take extra credit for jumbo cases, etc. But so that those would, I would imagine, be forwarded up to this working group by staff. But there were a small, but I mean still considerable number that checked all the boxes, and that still there was like like there's something wrong, and there was a little more digging, and it got to the point where, where staff contacted the applicant to answer some of the discrepancies. So it's a very long-winded way of essentially echoing Donald's concern that if there are a certain number of applicants that essentially get no review by a certified specialist that's on one of these working groups or on an advisory commission, that would definitely concern me.
So I have a question, and it goes along those lines, and then again, being the public member and understanding what you're talking about, I think that the peer review and the references are important. So how does staff, or how is it anticipated that staff is going to look at the references that are given and be able to validate that that's a good reference, right, versus just a reference, right? Because I think that that's important, and that's kind of what you're alluding to, is that without somebody representing that understands the people in that space, it's just a name in a box, and as long as there's a name in the box, the check goes and it goes through, so, right? So how would staff vet the references?
Sorry, I just have a quick question. So currently the references have some, there's a judgment statement like within each of those, or a scaling.
Yeah, so they, on the individual inquiry references, they indicate that they recommend, do not recommend, don't know the applicant, or just have no comment, or leave additional comments on the application, but they're all assigned with a bar number, so we know that they're attorneys or judges, and specialists too, they do note that.
So what happens when these references come in, because this peer review, and because you have peer review that's diverse from throughout the state, when we would look at some of the references, by the references you can tell if someone's kind of hedging, if they're giving a certain review, but they know the person better, and it's because we're peers that we can understand the actual references that are being given. We had situations where there were people who were their applications seemed fine on all four corners, but they left out. We had one, they left out that there was a string of malpractice actions that were filed against them that didn't show up, and staff would not have known, but for the fact that we were all practitioners and knew what was going on with this person. And I remember when the consultant came in, we talked to him about the peer review process, and my impression was he was quite surprised and wasn't really fully aware of it. And I think this is, I said it before, and I think we've all said it, this is a cornerstone of this process, and it's critical to protecting the public interest, that we had this peer review and it not be lessened in any way. I would really be disappointed as a professional, as a certified specialist, if people who should not be recertified or certified slip through because there's some type of digital process that they are able to get through.
Well, I guess my question is, the parameters that we have to work with are the fact that the advisory commissions are going to cease to exist, probably by mid-year, and that we are trying to establish these working groups as a way of still harnessing some of the expertise that they bring to the table and lend to this group, because eventually the applications come to this group too, but I understand also this group has gotten smaller. It's a loss of other specialty areas, so not everyone's going to be familiar with these applicants. But given all of these and what we have to work with, do you have recommendations as how we can carry this out? Because there's two things that we need to be concerned with, and one is that the size of these groups are part of how the determination was made that they were going to go away. It's, we currently have like 99 or had 99 extra members, and that is a large number. However, we also have highlighted that we can establish these ad hoc working groups, and maybe ad hoc means you meet on a more continual basis, but I just want to find out, is there other suggestions? I just came up with one about 3, and that doesn't seem to of having 3 members meet on a quarterly basis, maybe that's insufficient. Are there other recommendations or things that you might want to recommend, given that, these groups will sunset?
Well, I mean, 3 is a start. It's certainly better than 1 or 0. I mean, I would think, to echo Lou's point, I think the public, if they could see the deliberation and thought that went into a lot of these certification and recertification decisions, it would have given them a lot of faith in the specialization process, frankly, and I think it was one of the biggest value added from the advisory commissions that I saw on ALAC, and I take it that it was from others as well. But I'm just worried that we're going to have stuff that we're going to have something that, like, look on paper, it looks like, well, we still have these reviews of by 3 people from each specialty or 5 people, but there's something different about, say, meeting in a teleconference where everybody's reviewed a bunch of PDFs online, as opposed to like a robust meeting where people are actually, hashing out some of these problematic applications. What I would say is at least having 5 from each, 5 people from each specialty group that would have, again, it looks a lot like the advisory commissions at that point, but at least who would be on essentially kind of like constant call. That they would be kind of like a task force, like the working group task force, whatever you want to call it, that could be accessed, and also with the understanding that when in doubt they should be referred to, as opposed to staff's just going to try to figure 99% of the stuff out and only the 1% most problematic would go to this working group. Like more of an expectation that these working groups are going to be very actively involved in certification decisions or in the exam development, that sort of stuff.
Okay, thank you.
Right.
Any other?
Well, let me ask this. We have 2 public members. Maybe we can hear from them what they think about having a peer review as opposed to a bureaucratic review without peer review.
Well, I think I already stated that I think that it's an important part of the process, because just having boxes checked says that you did some work, but it doesn't necessarily mean you're qualified to call yourself a specialist, in my opinion, right? So I think that is important, not only because my understanding is it's not just about doing the work, but it's about recognizing that your abilities within the area as a specialist. So I don't think that a computer can necessarily judge that without having somebody looking at a file.
Yeah, so I'll echo the very same story. So institutional knowledge, as we all know, is key. That's why the group exists. We exist, sorry, and by the way, sorry for twice. Okay. So my point is institutional knowledge is key, and it's a key function of this body that helps to ensure that we have the right certified professionals in place to protect myself and other public members. I can also say, as a computer specialist, it takes time for the new application AIMS to get anywhere close to beginning to make some of these independent decisions that this body can make. And I think, as we put these groups together, we should look at how do we have better decision-making processes within the AIMS application. I know right now it's just going to replace the functionality that it has, but beginning to build in any type of artificial intelligence is going to take yet another step and another leap to get there. And to begin to say that it's going to replace this body or the value add that this body has brought is going to be a while off, if at all.
So I just want to clarify something at this point, and that is we never intended to have artificial intelligence or the AIM system do the spot checking. We have, if you look at the rules now, it requires a 2-person sign off And we're still considering that. We're using the system just to help us ensure that we have all our material, but we'll still have the 2-person check. The 2 people happen to be 2 staff members. So the it's not an automated system by any means. So there is some, human intervention, and it's 2 people reviewing the application process and flagging those that would go to the advisory, to this working group. So, but yeah, so I just want to clarify that. But it's still, the concerns that have been expressed here still exist even in that model.
And I wanted to make something clear if it wasn't clear before. All of my interaction when I was on ALAC, when I've been here on these applications, on other matters of exam bills, staff here is fantastic. I mean, like I've had a very good experience, dealing with, particularly with the certification and recertification applications, and like gone through like essentially the grunt work, so like we don't have to go through like that basic check. But what I would emphasize is this isn't a question of staff not being able to do it. It's the question of a non-specialist. Like if I were to look over an immigration application, and I'd be like, look, this looks fine to me, and Donald might see like a million things wrong with it, for example. Same with Lou's bankruptcy. Like it's not necessarily a question, because I think staff here has, in my experience, done the best job it possibly can without the specialty without the specialized knowledge that goes with being one of the specialists on those commissions. And I think that to the extent we're going to be having applications that go through with 0 review from even 1 specialist is, at least from my perspective, is troubling.
I just had a suggestion to add to the discussion. So I know we talked about staff flagging files for review that may be complicated or complex. There is a way to automate a list of names of applications that may have been approved or appear administratively complete. Could we incorporate that into maybe these quarterly check-ins with the working groups, so they can at least audit some files upon request? The current automation and the way that the system works, we don't have those paper applications, so they're not very easily reviewable, but we can provide a list of the names, and if there's any files you want us to print and have ready for the working group to discuss, that way they can at least see the names before they go to CBLS approval with that.
So there are no more paper files?
Correct. The applications are going to be all completed on the portal, community portal.
So, and the references and everything's going to be?
Online, email would be the surveys or INR, so no more yellow sheets.
I think that I'm not prepared to say what would be appropriate. I think that the more access to candidates that the advisory commissions are given would be better. They may be able to more articulate how they want applicants or candidates to be flagged for their review. Is that helpful?
And also, this is a very related but different subject, but about the working groups, because we're all focused right now in this conversation that we've been having on the applications for certification, recertification. Exam development. If I had a nickel for every time I had been in that ALAC room and there had been an exam question that 80% of people thought was fine, and then 1 or 2 of the best appellate practitioners I've ever seen say, no, there's actually this, it's ambiguous as to this thing, this little tiny thing, and this could cause the person to answer it this way, and that would be right too, and that would change the key. Frankly, that might be a bigger issue than the certification or recertification of applications, because I don't know, was it thought that the entire exam would go to a working group that would then parse each individual question, that would each then give feedback? How would that be handled? Would they handle it soup to nuts with the people that have been paid exam, that are paid to write questions?
Yes.
Because that seems like something that like staff, that almost seems impossible for staff to handle without a specialist involved, like whether these questions are good or.
Yeah, I mean, I'll look at the update later for exam development, but essentially for 2019, for the upcoming exam, the advisory commissions will complete this exam.
Okay.
We'll get their selection choices, and they'll be kind of just finalizing at the March meeting, potentially through May. Moving forward with the EDGE team, the LEDGE team that Amy mentioned, graders and exam development. Sorry, you wanted to chime in. We will have the consultation of people who have participated or have been members of the larger state bar exam. Those are the exam consultants that you've worked with during grading, so they are experts in exam development, kind of leading teams of the specialists who ideally have drafting experience and grading experience to kind of support that when needed in the future. And that's kind of the structure we have in place in mind for grading for 2019.
The other thing that we want to implement is an item banking solution, which we haven't had, and that is an electronic storage system that maintains, like our current questions, future questions, and whatever the case is. And I know that it doesn't mean that we'll just constantly be pulling from this bank, but it's a start for us to have a pool as well as this, pool of EDGE team members that, at this point, what we have is the current exam consultants. So that process reflects pretty much the current practice, but it's a matter of people getting converted into paid position, whether it's grader or exam developer.
But that seems like the exam development portion. My question is more essentially on the quality control end. If I had a nickel for every time I drafted a question that I thought was perfect, I'm like, oh my God, I've thought of all these questions, like all these multiple choice. No, that one's clearly wrong. And then it got in the room at ALAC, and people are like, well, this could be right if you did this or that. I think, yeah. How many levels are there going to be of, like, again, it's what I asked before, like, would the entire exam go to, say, like a 5-person kind of working group that says, hey, do you have any problems with these questions? Please write down the questions. If there's any problems, like, everybody's going to consult with it. Has that been fleshed out, or are we still at the preliminary stages of figuring out how that will work?
Well, we're going to model it after the bar exam. The way that works is we have somebody who develops the exam, a pre-tester, and then the exam consultant. So it's about 3 levels of editing and reviewing before the final determination is made as to what gets in the question. So what question gets on the exam.
I think what Roy is saying, and we had the same thing with the LAC, I can't tell you how many scores of questions that I wrote as a volunteer, and how many, dozens of essay questions I wrote as well. And I thought they were great questions, and then when they got into the commission, it was that level of scrutiny among the peers in the room that got these questions to where they were proper for the exam. And what we all were able to do is we had different levels of difficulty. Literally, that's what we thought through. We have a kind of a bottom level, a middle level, and a more difficult level. And it was a way of discerning who should be a specialist. And what often doesn't come out in the exam questions, and what comes out in the advisory commissions, is that, because we had this with the exam consultant, you have someone who comes into your office, and they come into your office and they've got a ton of facts and a ton of issues. And they sit across from the desk and they're just spewing out all these facts. And you as the professional, a certified specialist, you very quickly have to figure out what their issues are and be able to begin advising them. And that went into the exam writing process, that it gets lost in this process. And it was so important. I remember having a conversation with one of the exam consultants because we had written a question on the BLAC, and it was a very difficult question, and very few people got the correct answer correct. More people got one of the wrong answers wrong. And he said, well, that must be that the wrong answer is the right answer. And I said, no, because when you read the question, if they didn't understand the question properly, they get it wrong. And if you get something wrong, you malpractice. And that's got to be, that doesn't come out except in the peer review of exam writing that we were doing on the LACs.
So if I may, I think that from where I'm sitting, like to sum it up, is that there has to be an additional scrutiny on the level of the questions, because if we're going by checkboxes in terms of did they pass the exam as one of the checkboxes, and we're not scrutinizing the questions with peer review, and we've eliminated the peer review in terms of reviewing the applicant itself, are we watering down the program? And we're making it easier is a bad word. Can somebody get by without there being scrutiny on the exam questions and then scrutiny on the application to become a certified specialist without actually meeting criteria?
And remember, the difference here between what we're doing, the bar exam is are you allowed to get through the front door? Do you have the minimum qualifications to get in the front door and be given a license? 5 years into that room, you have a choice of whether you want to become a certified specialist. At that point, you're a practitioner. You're representing the public. You have got individual clients that you represent, and it's, are you proficient in this specialty to become considered as a certified specialist? It's a very different scrutiny than someone who's just coming out of law school and knocking on the door and saying, can I become an attorney, a licensed attorney? And that's something that we've always discussed here. It's that different level. And that's why when we wrote the exams, it was, you have a client sitting in front of you. These are the issues that come up when a client sits in front of you. Someone who's taken the bar exam, that's not the issue. It's, do you know the black letter law? Do you know how to apply the black letter law? This is very different. And I'm concerned, and I've always been concerned, and I voiced my concern that this program, as you said, Rob, can be considered being watered down because it's no longer peer review on the exam writing. Now there's no longer peer review on whether someone should become a certified specialist or continue to be a certified specialist. And so where's the public protection element at that point?
I can just add, you had mentioned that on the commission, they did the drafting for the examinations for that upcoming cycle. I did want to remind everyone of the drafting program that was approved and launched last year. We have thousands of multiple choice questions and hundreds of essay questions, all of which have gone through a dynamic process that the commissioners are familiar with. They draft the question, it goes to the consultant for feedback. They draft it, the consultant has signed off on all of these questions. So that process has happened in a dynamic, very condensed time period that would normally happen on the advisory commission level over the course of 2 years. So, pending pre-testing feedback, all of these questions has gone through the same process as the questions drafted by the advisory commissions. So that review, that dynamic process of the certified specialist drafting questions and having it be finalized and given feedback by a professional exam consultant, that has already happened for these drafted questions, ready for the bank, ready for selection.
Right.
I just wanted to comment on that, especially on behalf of immigration.
Yes.
A lot of those questions, a lot of the issues that come up are agency interpretations and changes that are frequently happening.
Mm-hmm.
So I hope that there's going to be some type of review by more than just one person before utilizing any of the bank questions for essays, because it would be horrible to be testing people on things that have changed when you have a model answer that's no longer applicable.
I remember that from when we had the opportunity to look at the questions, and it was at the time when there was a lot of questions about DACA going on, and whether we had to throw out a question, reword a question
Yes.
at that exact moment. So I agree again. From
Because
the
we are
public,
testing on a specialty, and those
Yeah.
specialties are changing
Yeah.
based on our practice area. And it's just a huge loss to lose that peer element, and I mean, you know, I see you're changing the word members to licensee. I mean, you're getting into check A, B, and C, and it's done. And the program has not been that way in the past. It's just sort of.
In the interest of kind of moving on to the next point, is there anything else that anybody wants to bring up specifically as it relates to this?
I have a question. What's the common practice in other states? And do they have similar boards in place that provide certification and help protect the public? And then secondly, has there been any studies done in regards to, you know, when this, you know, group is sunset? You know, what's the likely outcome? And what's the expectation of public protection of that one?
So you, the question is about the CBLS composition, like, do other jurisdictions use a model with an advisory commission?
States.
That, other states that provide the input for whether it's exam development or certification, recertification. You know, if you look at the Appendix I report, I think in the original large draft, it had an explanation. I'd have to pull that up, but some of that has been assessed and evaluated as to how other bar jurisdictions carry out their legal specialization process.
I would just add one last thing, just in terms of the process that like the exam, what questions go through. We had numerous times on ALAC where like it would get through that final process, and then in putting together the exam, when the entire commission was there, that was the final time where we realized that a question wasn't good enough.
Mhm.
And so, and what my fear is that under the new system that we're gonna have, that question would get on the exam.
Mhm.
And it would never be in front of a commission where you could have enough eyeballs on it and have one person go, hey, if they interpret it that way, and then you have 2 or 3 people, yeah, you know, you're right, because I had this motion that I filed this one time, and it worked this way, and it would take off, and you could essentially save the exam from having a question where you have 20 to 30% of people going off on a tangent that wouldn't get credit. So, I mean, and again, to be fair, that didn't happen when it got through a lot of like the final steps. That didn't happen on a lot of questions. Usually those things got caught, but not all the time. And so if there's not review of essentially choosing those questions in a group that at least approximates what the advisory commissions did, I'm worried that we lose that last very critical bit of quality control.
So with the working groups then, will there be an opportunity to constitute a working group who would then be tasked with, like what Roy said, maybe taking or going through the exam and making sure that the exam is constituted in such a way that it does maximize the public protection component of the CBLS?
That was going to be one of my suggestions. Is we've talked about the idea of the working groups coming together on an ad hoc basis, and this sounds like it would be right for that, so that we can have like a preliminary review of the questions before they get too far in development. So I think it seems like an appropriate use of a working group.
But even as an exam as a whole, okay, that the exam, for example, in the BLAC, we always tried to balance the exam so that there were, you know, Chapter 11 questions, Chapter 7 questions, Chapter 13 questions, trustee questions, creditors committee questions, creditors questions, debtors questions. There's so many stakeholders in bankruptcy. And because the specialty is now an umbrella specialty under which all these different what would otherwise be subspecialties, you have creditors and debtors and business and consumers, because it's all under one, we try to have it so that the exam was balanced so that someone, if for example, if it's heavily a consumer exam and doesn't have cover enough Chapter 11, and a person becomes a certified specialist in bankruptcy, well, then they can go out and do Chapter 11 cases and really have no ability, specialty to do those. So it was encompassing a balance of the bankruptcy bar and the issues that fall underneath the bankruptcy umbrella, that under the BLAC, we tried to balance. And that's not just each question, but that's the entirety of the exam.
Well, and that is, would be the responsibility of the ledge team, is to look at the exam for its overall
Okay.
flow in terms of, the difficulty, the question type, what it's gearing at. And each of those ledge team members we're trying to access people with the experience in that specialty, as well as having a strength in exam writing
Okay.
and exam development.
Okay.
So that's the goal, and that's how we actually work with the bar exam itself too.
Is that how the ledge team's capacity will be defined?
I think we have to establish criteria. For example, on the bar, the edge team, we have people who've had experience as exam writers, and we pick the strongest members to also, you have to have, like for example, pass the bar exam within I think 1 or 2 times. There are certain criteria. I think we need to develop that so we actually have a strong members making those determinations.
Okay.
All right.
Is that the end of Appendix I? And we move into recent developments?
Yes, that's it.
Perfect.
All right. All right, so recent developments, just an announcement that the California bar exam is coming up on February 26th and 27th. We have 10 sites across California and approximately 5,900 examinees that are registered and eligible to take the exam. On another note, we also have the legal specialist exam coming up. It is scheduled for October 22nd. We will be at 2 sites, in San Mateo here in the north and Pasadena in the south. Registration will open March 1st. As we've mentioned earlier, this will be the first time that exam enrollment is going to be online using our AIM system. And we are going to establish the typical fee rates that we have. That is early registrations about $350, late registration, which happens closer to the exam, perhaps I believe in September, is $600. And as with all our exam applicants, there is a $150 laptop fee that will be included as well.
If I can ask one question, just is it March 4 or March 1?
March 1, which is that Friday, I believe, that registration opens.
Okay. And then in the past, we've been encouraged, the board members have been encouraged to go to the testing centers. And are we encouraged again to attend this time?
Yes, we will bring, prior to October, we will have badges and information so that you are able to come and attend the exams.
Great.
All right. And,
There's a question.
oh, yes.
If you're gonna want any of us to go, if you're gonna want any of us to go to the testing center, are you gonna potentially change the location of where they put us? Because last time Bob Vermes and I went and people entered over here and there were other tables and we were way over here and no one went by us. We had to literally go out and grab people. So we need to be closer to the line of traffic.
Oh, okay.
That's,
Was that an admission ceremony or the testing center?
Oh, I'm sorry, it was the admissions.
Okay.
Oh, yeah. And
Yeah, they always put us in line.
we are also going to be also soliciting members to participate in the admission ceremonies as we get closer to that. And those dates are, again, in June and in December.
And will we have emojis? It's the most important thing, Adrian. Okay.
So that's it for the staff update.
Okay, perfect. Then let's move on to the consent section of, this is actually,
Mr. Chair.
yes, sir,
I brought up the issue earlier about the rule change.
but the conflict of interest?
Yeah, where would that be?
Yes, thank you.
Adrian, were you able to find it?
Sorry.
You can access it through Facebook. It's true.
Which rule is it that I'm looking for?
6.70 or 72. It's the ethics rules on sub-entities.
Here it is.
You scroll down, you can open up the text form. Too far.
Up.
Up.
Down. Oh, so you want this proposal part?
Right where it says here to the right? In
There's,
red?
yeah, the new rules are, but then you can see the text.
It
Oh,
says
right
right there. Yeah.
There you go.
Sorry.
That's right. And in particular, it's non-financial conflict of interest. I think it's 6.7, I think. Non-financial.
6.72
Go
or?
down, yeah, go down, no.
And it was in the
Other way.
non-financial. Keep going.
Yes. Personal conflicts, okay. All right, it says sub-entity members are disqualified when they have a personal non-financial interest that prevents them from applying disinterested skill and undivided loyalty to the state bar in making or participating in the making of decisions for their respective sub-entity.
Is your microphone on?
No. Okay, so for me, I guess I'll say it. I don't pledge an oath of loyalty to the state bar. My pledge is to uphold and defend the Constitution of the United States and the state of California. Kind of always troubling when a bureaucracy seeks to have someone pledge an oath of loyalty to it. I certainly wouldn't. I won't. Until things change differently. That's my position on that. But I'm concerned what this really means. It's rather vague, and I just don't know what it means, and I'd like to have a better explanation of what it means.
Okay, well, two things. One is I mentioned that we are in the process of a public comment period. So one way to address that is to submit a public comment related to this. And, you know, in terms of pledging undivided loyalty, you know, I think that's a matter of, you know, yeah, if it's something you want to address, I would put it into the public comment.
Okay, so we're a sub-entity. We're members of a sub-entity. Could we have that conversation among us at this time?
Yeah, we're just talking, the most important thing is under Bagley-Keene is that items are agendized, and this is a current in public comment period, so if we want to have that discussion, I think we can.
Yeah, I believe we can have discussion, we just
We
cannot take an actionable stance on anything. So,
This is problematic. I would think for everyone.
Right?
Yes. It's very far reaching.
and who makes the determination of the undivided loyalty to the state bar in terms of disqualifying somebody?
And to me, the state bar is a bureaucratic regulatory agency. I'm sorry. I'm bound to uphold and defend the Constitution of the United States and the state of California.
So Lou, is this a semantics issue where if we were to make recommendations that we would request that it be undivided loyalty to upholding and defending the Constitution, or removing or striking. Again, we can't make actionable item, but we can definitely have it.
I'm troubled with that verbiage.
Well, I think that all sub-entities would be concerned about the verbiage and may have no interest of serving on any sub-entity on behalf of the state bar. I mean, it's just, I appreciate Lou bringing it up because I had not previously read it.
Also, there's the fundamental question, maybe almost like a meta question of what is the state bar? I mean, like when we're on the board of legal specialization and we are looking out, say, for the interests, like the public protection purpose of the specialization program, making sure all these things, it's like perhaps there are situations where there are some things that are intended by the state bar or by parts of the state bar that may either affect that public protection purpose or that sort of thing to what we think to good or to ill. I just don't understand. I don't even understand what my undivided loyalty to the state bar is. Is it undivided loyalty to the CBLS, undivided loyalty to the state bar and its stated public purpose? Like I don't, I'm just a little.
So if I can ask a question, because I think that everybody in the room, I'll go on a limb and say that there's problems with the way that it's stated. So seeing as that we as a board can't make any recommendation right now back, is what your advice is that each one of us should go in and make public comment on this? What is the appropriate way for us to raise a concern about the way this is worded?
Is this not our public comment? Is this not?
Well, I don't know if there's a formal process that we need to follow in addition to this, because these minutes won't be received until next time, right? So I don't know when
Can we have,
Well,
can we have this conversation transcribed
Well, given that this is, we did not agendize this item, that we have it as a discussion and we're not making a motion on this,
Right.
I think the only remedy would be to make it a personal public comment.
We as a
From
board
each
cannot,
of you.
we as a board cannot make a motion to send a message back, is what I'm hearing, right? Because it's not been on the agenda, and it has to be on the agenda for us to take an actionable vote on it. So the recommendation is that each one of us take a personal stance. So how do we, if that's the way we need to go, take a personal stance and public comment on this?
I will send everyone a link to the public comment item itself. So at the end of this meeting, the CPLS will receive a link to the public comment process. So they'll have both the agenda item and like a form for
And if I can ask also that it get introduced into the minutes, the actual link, so that anybody that reviews the minutes that wants the opportunity can make the comment that way as well.
So can I ask a quick question? So just today, we've had a lot of discussion about the advisory commissions, working groups now, and all these new changes. I mean, this information, I'm assuming, is coming down from board of trustees, ADJOURN. So therefore, under this rule, undivided loyalty would mean that we don't have a comment and we throw our support in favor of anything. I mean, that's the question I have, because, I just think it's very important to have these open discussions, and it's just the wording of that is very
Problematic.
problematic.
And I
to be able to
asked
say
that this be
board.
agendized, and it was not.
you asked.
I don't know if your microphone is on or if your computer's blocking.
I asked that this be agendized, and it was not.
That this specific rule 6.74.
Yes.
I did not get that request, but
It seems to me we can't, well, we are members of the public in essence. This does directly impact us. And I guess it can go on the record how we, and this is our record, how we as the public and as members of the sub-entity view this. I mean, for example, we've had the discussion of how we all consider the importance of peer review and and in both the exam process and in the peer review of candidates and applicants. And if what we're saying here is not consistent with the dictates of the state bar, could it then not be said that we are in conflict and are not loyal to the state bar because we have a difference of opinion? I'm troubled by that. I'm troubled that a difference of opinion could be construed as being a conflict of interest. I think we should all be concerned in this room about that.
I think your point is taken.
And it's in the public record. And so I want my opinion, and those are any others who want to make it, to be the comment of each of us.
I think, Lou, that it'll be introduced in our meeting minutes, and so therefore it is part of the public record. But in addition, it sounds as though what the best course of action is to take the additional step once we have the link, to then also file a formal objection with the public, as a public member, sorry.
But as far as the minutes go, they don't get approved until the.
They will not be approved till the next meeting, so that's why I think it's critical that you take your stance online.
And I will still send the link.
Can we have the minutes prepared earlier and we have the minutes approved?
We would have to schedule a meeting.
We would have to have, we would have to have a meeting to approve the minutes, but we could do that potentially via teleconference.
That's what I was gonna ask, do we actually have to have an in-person meeting to approve it, or can we just?
I don't believe so, we've
can.
approved other things via remote meetings, so.
It should be doable, if it's not, right?
Yeah, so I guess the
It could
question,
be a meeting, it could be a special meeting with essentially just two agenda items. Like the
Correct.
first one to approve the minutes, and the second one to officially move to forward the minutes and our comments as our written comment on this.
so I need a kind of clarification on how far out do we need, is it 45, do we need 45 days to plan a meeting with an agendized list so that we can then request it to go in? When could we officially have a meeting to review and approve the minutes from this meeting?
Public notice of agenda is 10 days.
Yes.
10 days?
We need 10 days.
Okay, so that's
Can I
it.
ask a question? Can we
Yes.
not just do this electronically?
That's what we're saying.
Yeah.
So send out the, just approve it.
Yes.
Yeah, I don't know if that I'd have to ask you that. I don't know if we can do it electronically, meaning yays and nays coming back in response, or if we have to formally conduct a meeting even if it's on the telephone. I don't know.
But let me just clarify, what I heard too is that you wanted to, discussion as part of the formulation of that motion. So it wasn't just a vote, right? Because it sounds like that would put a motion on.
Do we want a discussion or do we want a statement? I mean,
Well, it's technically not agendized, so we cannot vote on it, but we can certainly articulate a statement.
Right. I believe
From the CBLS.
what I'm hearing is that we would like to schedule a meeting as soon as we can, officially with 10 days of notice of an agenda, with 2 agenda items at a minimum. One is approving the minutes from this meeting, one is having a discussion regarding the wording of this,
Yes.
so that we can take an actionable item and submit this to the Board of Trustees.
Yes.
And I can bring somebody from, like our Office of General Counsel that can give more background on the rule interpretation.
So I think the next step will be after this. Oh, I'm sorry, please.
So since this is not an agenda item for today's meeting, can we, under new business, make a motion to do that?
Yeah, I do.
At that
That's what I was gonna say, is I don't know what the procedure is to formally say we wanna have a special meeting in 10 days or whatever it would be. So I believe that will come up in new business, yes?
Yes, so
Okay.
we'll just,
So that's, we'll
take that
handle that
request and then.
into the new business section. There is an additional, additional developments in the recent development section there was no slide given, so I'm gonna turn it back over to Amy. Thank you, Lou.
And that is related to the CBLS. At the end of this year, we'll have 4 vacancies, and I just want to highlight that applications are due on March 15th of this year for those 4 vacancies.
And to date, have you received any applications? Okay, so I think that closes then the recent developments.
Adrian, how are you going out soliciting applications? What's the process?
We will, we plan to reach out to people who actually applied last time, that they weren't, approved for this last term. So we can reach out to those applicants, see if they're still interested.
And the 4 vacancies are all attorney vacancies, if memory serves, because Cynthia and I have not been 4 years on.
Cynthia, there's a vacancy coming up.
Yes?
Yeah, Cynthia has a vacancy.
Okay.
Based on the chief, it says for terms 2019.
Wow. Okay, so at least 3 attorney and possibly 1 public member. Okay.
Well, why was Cynthia's only 2 years?
Did she fulfill someone else's?
Yes.
Yes. She filled the vacancy.
She came in to fulfill a vacancy that was open.
I thought it was a 4-year term.
Yeah, that was a 4-year term.
Maybe it should have been.
We'd have to go back to those meeting minutes.
It's just
Someone
listed
vacates a
here.
position mid-term,
No, I don't think so.
imagine like that term still exists and then we just put it in the middle of the term.
I'll go back to the letter. I thought the letter was 4 years.
Yeah. So one, drops the one.
Well, let's keep moving on, because it's coming up on 12:25, and we still have a little bit to go before we break for lunch, if we can get through. So let's move on to the consent section, which is the approval of the November 20th, 2018 Board of Legal Specialization public meeting minutes. Everybody should have received those and hopefully has had the opportunity to review them. If you need additional time now, let me know. Seeing that no one is raising their hands, then just call for a motion to approve and receive the minutes.
So I'll make the motion, Mark.
Second.
Okay, motion by Mark, second by Lou. All of those in favor? Aye.
Aye.
Any opposed? Okay, the motion carries. Okay, moving on into the business section then. We're going to start with the report on financial and operational key indicators. Amy?
So the key indicators, the key indicators are a standing agenda item for CBLS, and they serve to inform the board on the health of the program. There are 4 central indicators, and for this report, for example, in our expenditures, the report demonstrates that we're operating financially sound. Revenue are outweighing expenditures. The report is reflective of November 30th, as of November 30th, 2019. So I just want to point out that this report does not include year-end invoices that were received up to the end of December. And that would include invoices with extensive exam development work. So we imagine that these, while the revenue outweighs expenditures, this might change once those December actual financial figures are incorporated. The next part of the report looks at growth, specifically the amount of specialists. And in this report for this period, as of February 1st, there were approximately 4,929 certified specialists, as compared to last year when we had 4,866. So it's a small increase.
By the way, I'm sorry, can I just jump in real quick, because that attachment B, like the overall number of specialists, the numbers are out of whack. Because like they don't correspond with the right specialty area. For instance, like it has appellate specialists listed as 1,000 and there's like 300.
Bankruptcy, it has bankruptcy at 315 and bankruptcy is 165.
Right, it's got admiralty at 343, it's a lot smaller, so. I mean, I think that the numbers are probably right, it's just like the
In the wrong columns?
yeah.
Right. And estate planning is well more than 210 specialists.
Yeah, it's a ton, yeah.
Right.
I'll note then, correct that for the next meeting, I apologize.
Was a sort order.
The overall total is correct. It's just the numbers for each specialty are wrong.
Column A wasn't chosen when they did the sort.
Column A was not consulted.
Okay, thank you.
Thank you. Also, the next report looks at resignations. There's been a slight decrease compared to last year. We're at 47, or actually larger than slight, and last year we had about, for the full year, 161. The last part of the key indicators report highlights those that have been maintaining their certification. As everyone's aware, certified specialists must take 36 hours of specialist approved continuing education or an equivalent. And this report looks at compliance on a 3-year cycle. This is for group 1. And as you can see here, we have about 19.6% that had not reported their status. The report compliance is due February 2nd, and we are extending that deadline to August 31st. All right, any questions?
Questions or comments on the key indicators? Then we need a motion to receive them, obviously, based upon the revision of the correction. So is there a motion?
So moved.
And a second?
Second.
Okay, all in favor?
Aye.
Opposed?
Aye.
That's a yes, not a no, and so the motion carries. And then moving on to the report on legal specialist examination, successful applicant post-examination status metrics. Adrian.
So this report actually has 2 parts. We'll be looking at the applicants who passed the 2015 legal specialist examination. First, they had until January of this year, January 31st, to file their post-exam application. 80% of those successful applicants have already filed their application. There were a couple that had indicated they no longer wish to pursue certification. So there is a staff recommendation to extend the deadline to allow the remaining applicants to submit their post-exam application to March 31st of this year. And this will actually be consistent with an extension that we offered to the 2013 applicants back in 2017. And then the second part of the report looks at the successful applicants of the 2017 examination. They currently have until January 2021 to file their application. And since the release of those results, only a small number, 4.2%, have filed their application as of February 1st.
My one question is, have we moved it further than March in the past? Or has March been like the drop dead deadline?
I looked at the last meeting, it was, I think it was April 1st, just because of the day of the week that it fell on. But this will also be good because then we're meeting again in April 5th. 5th or 5th? Yeah, I think it's the 5th, so then we'll be able to review that list and see an updated number.
But in the past, have we gone past March? I'm just saying this because I'd be inclined to go to the end of May or something along those lines, to give even more time. Because just extending it now essentially for a month and a half, I'd be inclined to go out even further than just have to revisit this again.
If the board feels so inclined to change that date, we can definitely do
That
It's going out to
modified motion.
I would do that.
Yeah, this I believe is review and receive, so it would just be to accept this, we would have to make a motion to revise it and then approve the revised.
the two things is, the recommendation is to move and to receive. That's what I'm saying.
Yeah, so it would be that,
Modify.
the first motion to,
Would anybody I would propose instead of March 31st, May 31st.
Any discussion? Any downside, staff? I don't. So then I think we need, if I'm following this correctly, a motion to ask for a revision, to revise the proposal.
I will move to accept the amendment that was recommended to advise the
May
proposal.
31st.
To May 31st, the extension date to May 31st. So we have a motion to revise this to accept extensions through May 31st, 2019. Is there a second?
Second.
All in favor?
Aye.
Any opposed?
Aye.
So that the motion passes. So now, if I'm following this, we actually have to vote to accept the entire report, correct?
No, I think
That was enough?
it's in
So we accepted it with the change, perfect.
Yeah.
Okay?
Yep.
So that closes that section, moving on to the next section here, which is approval of extension of legal specialist continued legal education compliance deadline. That is different.
Yes, so this item is to request an extension of the legal specialist continuing legal education compliance deadline. That original deadline was February 1. Out of the specialists in that compliance group 1, 73% have reported their compliance. The general MCLE deadline has actually been extended to July 2nd. The only difference is attorneys who report to that extended deadline, they have to pay a penalty fee. But our staff recommendation is to request an extension to that same deadline, but there's no penalty.
Any comments or questions? Okay, need a motion to approve.
So we're gonna do it to the same date as the general bar.
Correct, and this is consistent with past compliance.
With no fee.
Correct, no penalty.
Without a fee. Without a penalty.
Is there a motion?
There's a motion. So moved.
Okay, Lou moved, second by Roy. Any all in favor? Aye.
Aye.
Opposed?
Aye.
Motion carries. Next, the approval of the advisory commission and staff recommendations regarding certification and recertification. Crystal.
Right, so there are two action items regarding certification for board consideration. The first one is regarding a single specialist, Tricia Toyne. Staff is recommending to continue the certification of her status. The agenda item lists kind of a description of what happened. A clerical error regarding her education requirement was found after she was certified on August 1st. It was under CBLS advisement to contact Ms. Toyne to provide the additional hours within 90 days, as she has since completed this request and is in compliance and meets the certification requirements. The second staff recommendation is regarding the revocation of certified specialists for failure to recertify. The specialists listed in attachment A have not recertified or requested extensions to recertify when they were due in various days through January 1st. Again, it's consistent with what the CBLS has voted in the past to revoke their certification status if no final response is received to a final communication that we send via certified mail.
Any questions or comments?
I just had a quick comment, a question on, because there was, I think this was last year actually, there was a change to some of the certification requirements, the MCLE requirements. And like for some of the specializations, appellate being one. And I was curious as to any thought was given for people that potentially, were they grandfathered in to the initial, to the previous requirements? As opposed to, like if somebody started their compliance period with one set of requirements and then all of a sudden it got changed to another set of requirements. And they come and they certify and they submit their MCLE and it satisfies one but not the other.
Is this regarding the subfield requirements for some specialty areas? Is that?
Yes.
I believe they were waived. Adrian, if you can confirm.
They have been waived, I guess, I'm a little confused as to what your question is.
Well, what, like, for instance, I mean, well, it's actually appellate specific because it's actually my goal to be board on this question, but like in there in particular, previously it had been, you could do half your certification hours in appellate and other law, and the other half is what's called substantive law practice, which was essentially taken to be like basically non-ethics and non-subfield MCLE could like satisfy that. And there was some change to that, and I had actually heard from other appellate specialists said, wait, does that mean that like instead of getting 18 specific appellate hours, we need 36 certified, the actual appellate hours, so.
Okay, the board did approve that, that change that you're talking about. However, the rules, the revisions to the rules have not yet been made or brought yet to the State Bar Board of Trustees.
Okay.
But that's definitely something that staff should look at, is going back to our current pending applications to see if they would be approved under that new guise. Because when they originally submitted it, it was under the original standard.
Right.
Yeah, so we can make note to relook at any pending appellate applications to see if they would now be approved.
Okay, any other questions, comment? Sorry. Any other questions or comments? Okay, then we need a motion to accept the proposals from staff on the two actionable items.
So
We have a motion. Second?
Second.
Second. All in favor?
Aye.
Opposed?
Aye.
Motion carries. Okay, next agenda item is the approval of interim advisory commission officer appointments. Amy.
All right, so as we discussed earlier, we plan to meet with the advisory commission through July. As a result of that, we seek your approval to nominate chairs and vice chairs for each of the advisory committees. So traditionally, this happened in May or June of the previous year. This year, given the Appendix I decisions that we were waiting on, that did not occur. So again, there are a list of 22 names that we would like, that also came from a previous recommendation that did not move forward last year. So the idea is to move forward with these recommendations and for these chair and the vice chair to serve as interim for this year.
Discussion? Questions? Okay, so we need someone to make a motion. We have no motion on the floor.
I move as recommended.
We have a second?
These are for the advisory commission.
For the advisory, yes.
can I second if I'm abstaining from the workers' compensation part of it?
I will second.
We have a second.
And I'm abstaining from workers' comp.
From workers' comp.
And also, I'd like to ask, so these officers would be appointed and then their commissions would be essentially being dissolved almost immediately thereafter.
Correct.
Yes, mid-year.
I just wanted to clarify.
Okay, so we have a motion and a second. So all in favor?
Aye.
Opposed?
Aye.
Do we have any abstentions other than what was noted? None? Okay, so the motion passes. And moving on then to a report on the Admission Information Management System, AIMS system status.
All right, so as you may recall, we have been in the development of a new admissions information management system that's going to, I guess, advance a paperless process for us in the admissions department. And Adrian is going to, conduct a preliminary review of what that system, so it's a preview. Just so everyone's aware, on February 25th, we are going live. As of today at noon, our current system has been locked down and tables are being migrated and integrated into the AIMS system for our go live date on February 25th. And with that, Adrian's going to give us a demonstration of what that system is going to look like.
Sure. So I guess it might be good to note that currently and prior to the launch of the system, generally the legal specialization program has been paper intensive. So we're hoping that creating this portal for applicants will give them better access to and better visibility into their certification records. So this is what the community login is going to look like. I'm going to go ahead and log in as a...
While Adrian's doing that, can I just make a statement? I'd like to recognize the efforts of Cynthia Levin as the public member of the CBLS and her.
Maybe you should move the computer a little. Oh, it's important where you're.
I want to recognize the efforts of Cynthia Levin, who's the public member of the CBLS, and her efforts in assisting the State Bar and its staff in its efforts to procure and implement this program. I think Cynthia needs special recognition, and she should be given that recognition.
Correct, and we definitely appreciate that she has attended a meeting or two as well. And also want to recognize the board in general too for providing some investment towards this, the development of the system.
Quite a bit of investment.
Alright, so this is what the community is going to look like when an applicant logs in. I guess if you're a currently certified specialist, you'll be able to look up your own certification record. Prior to this, specialists actually didn't really have much access or visibility into their own records. Let's see. So what that would look like for a specialist is you'll see your specialty area, some additional information which would be helpful for reporting your legal specialist education requirement. You'll have your compliance group here. You'll have your status as a specialist, when you were initially certified, and it'll also have your current term dates.
So we keep track of MCLE?
We will, and it'll be reported in the system, so it's not going to be the same method completely as reporting in general MCLE, but it'll be similar in that it'll be electronic now. Yeah, I'll definitely show you how to report the education in here too. And then if a specialist needs more time, they can submit a request, and then their extension date will be noted here. Going back to the MCLE, this is still in production. It's not let live, so I mean, but it'll have their MCLE due date and then the date that if they have complied with their legal specialist.
Nice.
Another
Adrian,
thing.
this is Mark.
Yes.
Is there going to be an opportunity for specialists who have not been particularly identified to put in an applicant or a non-support letter?
Sounds like maybe you're asking if a general attorney wants to submit interest and have access to the community?
Well, in other words, how is somebody, if we know that a specialist is up for recertification and that specialist shouldn't be recertified, in this paperless era, how are we going to be able to get submissions by other attorneys who would say that person shouldn't be recertified into this portal or into the record?
So it'll, I guess that would occur when this specialist submits their recertification application and they're submitting a part of that, their references. And then when those references are turned back to us, or going back to what the board was discussing earlier with the staff review and perhaps the working group, that we would identify that and then potentially deny their recertification.
So,
It wouldn't happen prior to them not actually having an application.
so essentially, the system's set up so that it allows for documents, external documents to be linked to back into this case file.
Did that answer your question, Mark?
No, not really. I guess we'll see how it works out. I mean, we had one in estate planning where we knew this person shouldn't be recertified. I was proactive in getting, the references out to 20 different people, all of whom came back with references saying this person absolutely should not be recertified. But with a paperless piece like this, how would that be accomplished?
Okay, I'm gonna make those notes to see how we may be able to implement that or take that into consideration during this new AIMS process.
Adrian, my suggestion is
Perfect.
to add it to your backlog, because there's gonna be times where you'll find you'll need enhancements on your records, and this is absolutely one of those. And so as you go through these type of demos, it's naturally to be expected, the use case, that you're gonna get more understanding of what the needs are. So just capture it as a backlog and share that with your product manager, with the team.
Perfect. Thanks, Mark and Cindy.
Great, thank you, Adrian. So moving on, oh, sorry.
Oh yeah, if okay, I mean, we can go through the system just a little bit more.
Yeah, I'm sorry.
I guess for applicants, if they're going to, this is where they're actually going to be registering for the legal specialist examination. Just to show it briefly,
So this is where applicants,
correct.
first-time applicants.
Correct.
Is it possible on the, well, I guess we don't have commissions anymore. Depending upon how these working groups are structured, could we have something on the specialist side where if they have an interest in serving the public
Yeah.
interest in the capacity of a working group, that there could be something where they can put that in, where they have an interest so that you can see that?
If we go to the screen, it's part of the general request. We may have to adjust the wording a little, but this type of request is indicate interest in becoming, once again, we'd have to adjust it, an AC member. We can change it to a working group member, or if they want to be a part of the exam team.
Okay.
And then for, we did a current certified specialist. If they wanted to, you could essentially log in or begin this recertification application anytime during your certification term. You can track your task experience. This one is an Admiralty recertification application where they log number of times they perform a certain activity. They can come in at any time, enter those numbers, it'll automatically save, and then they can come back in later and re-update those numbers until they reach their total. And then there's actually going to be a block that would, with current rules, you're not allowed to submit your recertification application greater than 6 months before your cert term ends. So we do have those internal validations and blocks to prevent certified specialists from submitting it too early. If a specialist still owes money to the department or to the bar, there's going to be those validations and checks as well. And then
I guess Mark's question was, can people put references onto, third parties put references onto their site?
yes, so I don't have a link to the current survey. So references now are paper forms. It'll now be an online survey. And then when a reference does submit that, they have the opportunity to submit a secondary reference. where the system would then automatically link it to that original application and then submit it out to that new reference.
And in that format, is it just check box, or is there someplace where they can be?
It essentially looks like the original reference form. So there are check boxes. Do you recommend certification? How do you know them? How long have you known them? Are you a certified specialist? What area are you a specialist? And then there's the
Comments.
The latter half, correct. There are comments where you can say, why are you recommending? Why are you not recommending? Or are other comments.
Right. It's often those comments that got picked up by the commissions, and that's where the conversations would take place in the peer review.
Mm-hmm. Yeah. That's definitely something that we can look at. I guess internally we'll be able to see quickly with the system now. It'll have all the references listed out, and we'll be able to see if there's comments left in those fields.
And would the certified specialist be able to see the references that are being put in, or is it?
No, so with the current process, specialists only see the names of who they submit. They do not see the outcomes, and they don't see who the secondary ones are. And that's still going to be practiced.
Okay, good. That'll be maintained. All right, very good.
And then I guess the last thing here is reporting your legal specialist compliance. I can't say for sure how it is done through your My State Bar profile, but it's currently going to be in the same format as the paper form. So attorneys would attest that they completed it or not, and then there's their verification. And then for all the applications or forms where there's a processing fee, that could all be done online. And something that specialists didn't necessarily have access to before was they'll now have a record of their payments so that they can see when something was paid, how much it was paid in.
Excellent.
Any other questions? Did anyone want to see any other functions regarding games?
I guess with this demo, we're actually hopefully compiling a guide for new specialists or those interested. So any other things that you might want to know, it'd be really helpful so we can capture it and address it in that guide in terms of like, what do you want to know when you're on the system?
Did Cynthia, I guess this is kind of for you, was there a UAT done on this where people provided any feedback and said this, for help them with the guide?
So I'm sure there was a UAT.
Yes.
And I think the other question we should ask is that what does the future enhancements look like so that we can help share with the group kind of after we do this testing, and as mentioned by Rob, the UAT, but also what's coming up next to when.
Okay, so we are using JIRA to keep track of both our backlog, anything else like stems from once we're in the system and troubleshooting happens, whether it's something that we need to fix from the applicant community portal or our administrator portal. So the idea is to keep that captured in JIRA and prioritize as we go through. We actually had 3 weeks of UAT scheduled and went to 8 weeks. And
let's explain JIRA to the population here. So JIRA is our problem log, our problem issue log or enhancements. And so as we do testing, which is UAT, user acceptance testing, as we test the application, information is being recorded in the application called JIRA. And but that way it just translates the language that we use into common language.
Yes.
And that way we continue with the efforts of the application and continue to enhance it.
Exactly. So that backlog becomes either it's a trail of documentation and you use that to determine whether you need a product enhancement, whether you need it's a fix, whatever the case might be. It's just the documentation that's required. And I also want to concur with Lou. Cynthia, you've been wonderful in terms of providing feedback on both the process and the expectations with us. So aside from helping us with the solicitation process, you've been very helpful with what staff can anticipate. So I appreciate that. Thank you.
Continue to work with me.
So any other questions related to AIMS?
No? All right, thank you, Adrian and Cynthia.
Well done.
Item G, discussion regarding potential new specialty areas. Amy.
So we have two new specialty areas that have expressed interest. So we have not formally received an application, but just so that everyone's aware, the National Board of Trial Advocacy that was accredited by the ABA in August in the truck accident law arena sounds like they have some interest in becoming a certified specialist here in California, as well as the International Association of Privacy Professionals, another ABA accredited organization. So they reached out to our office. We have not, again, formally received an application. What we want to do is share the current application right now with each of you to review, to find out and determine whether we have the appropriate criteria for consideration. Perhaps we can review these and give us feedback as to whether we need to modify it in any way. If there's more data that we need to be gathering from these agencies, or perhaps anything that should be modified. So we can do this now, but we can also.
Yeah, I think in the interest of time, if we can take this offline of the schedule, because there'll be no public discussion, I don't believe, necessary on this, and continue with the agenda to move us forward.
So when a third-party certification program seeks to get the blessing of the CBLS, it's just a $500 application process. Is there a per member charge that we have for each of their members that they pay to the state bar?
Yes.
As part of the initial application?
At any time?
Yes, so the certifying organizations, they have to essentially reaccredit themselves annually. And as part of that, they do pay a per specialist fee. I want to say it's $25 per a certified specialist in California. And then there's the actual renewal fee as well. Is that your question?
So they charge $25 per applicant.
Oh, no, we charge.
We charge them
Correct.
$25 per specialist.
Correct.
And then those people get to say that they are, how are they identified differently than those who are certified by the CBLS?
It would be on their, similar to the state bar specialty areas. On their My State Bar profiles, it'll say that they are certified in, what is it? One of them is criminal trial advocacy. And it'll say that they're certified in that area of law by the, who is civil trial advocacy? By the NBTA, excuse me. National Board of Trial Advocacy.
And are they then allowed to refer to themselves as certified specialists?
Correct.
So,
Because they're certified through one of the state bars, accredited certified organizations.
and do those people pay a similar amount per year to stay as members of their interim specialty? How does that work? Because I'm thinking about the price difference between what those who are certified directly by the state bar pay a year versus those who are certified through a third-party provider.
I have to I don't have that information readily available, but part of the initial application is they're establishing what their fees are, what their standards are, and then that they at least meet the California requirements. They do have their own fees that specialists would pay to that organization, and I believe that there is a requirement for them to recertify, and then there's those fees, but I can't say off the top of my head if it's similar, but I'll definitely make a note to have that information.
Do they have a peer review process similar to what we have?
For the individual applicants?
Yes.
Yes, I believe so. I don't want to say for sure, but I want to say.
I appreciate it.
Once again, is we want to make sure that their requirements are at least meet the California requirement, and since that is like one of the California requirements, I'm more than confident that they are, but I'd have to check with you.
All right, thank you, Adrian.
Well,
Appreciate it.
And in preparation for our next meeting, what we could do is develop a grid that's got that information by each of these entities, so that we can look at the fees and the vetting process as well.
Sure.
Okay?
Ongoing vetting process.
But yeah, initial and ongoing.
Okay. So that was the last of the items that were on here before we break for lunch and move into the closed session. We need to introduce that we wanted to hold a special meeting, right? And if I'm looking at the calendar correctly, we need 10 business days. That puts us at March 4th, the day before the meeting of the advisory commissions. Is that correct? March 5th is?
Oh, March
Oh,
7th.
I'm sorry, but no, the public comment period on, when is the public comment period, sorry, for Appendix I, for what we're talking about with the rule change for, the rule change regarding conflict of interest? When does that public session close?
I want to say it's March 18th. Let me pull it up.
So I just want to make sure that we can actually get the meeting in time.
I thought it was March 18th.
Okay, so we're
March
fine.
18th.
Okay,
March
so
18th? Okay.
So we have then, because March 4th is 10 business days from today, because there's a holiday in there. So we need to have a motion to hold the meeting?
Yeah, and it's probably, I don't recommend we do that day. Our agendas have to go through our Office of General Counsel. It's gonna take some time. I mean, perhaps maybe early on the 11th or even closer to like the 6th is probably the most feasible.
When's the cutoff date for public comment on the rule?
I think that's what,
That's what we were looking up. I think it was
March
the 18th.
18.
So we need to make sure that we meet before that date and that staff forwards our comments from our meeting
Correct.
in a timely manner.
So it sounds like there'll be 2 agenda items for that meeting. At least we can discuss it in advance. Is one being to specifically to discuss the conflict of interest rule and the wording that's in there, and also to approve and forward the meeting minutes from this meeting on, that would record the comments that happened in the general session or in the public session. So if you could tell me, Amy, what is the procedure then for us to hold a special meeting? What do we need to do? Do we need to make a motion today that we want to have one and staff comes back to us with the date?
no, I think we could make that recommendation. It's just looking like in terms of the dates, it would have to happen between the 6th and if we need a few days, the board meeting is on the 14th and 15th. Their items get agendized by March 4th. I mean, we're putting it very close. It's looking like either the 5th or 6th would be the days. If we're talking about a 1-hour conference call, that would seem the most feasible that we can achieve in that short time frame. So I'd say either March or 5th or 6th as a tentative date. Also, I just want to confirm that our agenda item is one, to have a discussion of that rule specifically, and secondly, to accept a motion from the group. Right, those are the 2 agenda items that we want to have on there.
Lou?
I move,
We're looking with discussion on what the agenda items would be for that meeting. So one will be to discuss, to have
the first agenda item is to approve the minutes of this
this
meeting.
meeting.
Okay.
Approve and forward the meeting minutes.
The second agenda item is to discuss the sub-entity rule 6.73, is it?
I think it's 6.74.
Okay. 6.74, to discuss and to make a recommendation to the Board of Trustees with respect to the language of that rule.
Okay.
Perfect.
But once that motion's made, that motion has to be immediately forwarded to the state boards. In other words, what my concern is that someone's gonna say, well, we can't do that because Those are in the minutes, the minutes have to be approved. If we make a motion on that date, that motion would be then forwarded as the statement of the CBLS as to the rule.
And we were factoring that in when we were making the determination of the date, because the board meets on October 14th and 15th. Cutoff period is on the 18th. So if you wanted to go to a board meeting prior to the closing of that public comment period, I think the recommendation is around the 5th or 6th of March.
Right, but the
Is that
motion
gonna-
will be, that whatever is decided that meeting will be forwarded.
Yes.
We're
We
not
would need
waiting
to
for-
approve the minutes from that meeting in order for that motion to get forwarded, is the
Right,
question.
Yes.
We
Okay,
have to chase our tail.
right. Okay.
All
Okay,
right. And so, and we don't have to make a motion.
nope, so that's with you, that's with
a
you.
recommendation to staff.
So I believe, unless there's any other discussion, question, or comments, that is going to bring us to the end of the open session, the public session. And we will adjourn at 1:05 for lunch here to return, how long do people need?
We're doing this on the 5th.
We're in lunch now.
No, I'm sorry, he's asking about the meeting, 5th or 6th?
Yeah, 5th or 6th.
Well, it will come out, it will be either the 5th or the 6th.
Okay.
Lunch, do we want to take we do not have what appears to be a long session?
I move that we have lunch.
Half-hour lunch or hour lunch? Half an hour? Okay, let's take a break then from, it's 1:05, we'll take a break until 1:30 for lunch, and we will come back with the closed session. So we're closing, officially closing the public session. And if everybody remembers to turn off their microphones, because the audio is still online. The tapes, I'm pretty sure I said this before when we closes it, we're gonna come back.
Who's that just retired? He says, go to the tape?
So, I don't know. What are you, Harvey Levin? I'm over here. Okay, so we can turn it on. Plus,
Excuse me.
like Shea Stadium. Hello? Oh, did you see? I couldn't find the papers because they got all out of order.
So sorry.
I'm sitting here going, what else? The second page.
I definitely need the 3
Are we good, Tom?
Okay, welcome back from lunch, everybody. We are actually going to conclude the public open session of our meeting right now and adjourn and move into the closed session. I don't believe we need to make a motion and to formally close the public, do we? No. So that being said, we're going to close the public session right now, 1:54 p.m.
So was the public supposed to be invited to lunch?